We're in the SuperTalk Studios. Joining us now, Pepper Crutcher. He's an attorney with Balch and Bingham, a longtime friend, and also provided much valuable legal counsel with respect to human resources and employment for many years to my company. Appreciate that, Pepper. Did a fine job. But we wanted to have you in the studio today. We just had these hearings up there at the Supreme Court concerning the Biden vaccine mandates. You sent me a note kind of summarizing that after arguments were made. What do you think about what happened? At first, tell us exactly what is being contested. What are the mandates that are being contested, and then how did they get there?
Well, that's the great question that you're not hearing in the news. The cases before the Supreme Court were really procedural and narrow on only two of the mandates. The CMS mandate that covers Medicare participants, the providers who are participating in Medicare, and the OSHA mandate that covers currently employers of 100 or more employees. And the question in the OSHA case was whether the court should reimpose the stay of enforcement of that rule, originally imposed by the Fifth Circuit and then reversed by the Sixth Circuit Court of Appeal. Mm-hmm. Not to rule on the mandate fully and finally, just should we stay enforcement, which, by the way, begins today, January 10th.
Okay.
The question in the CMS case was should they continue the stay imposed by the appellate court below of the CMS vaccination mandate. So a surprising amount of argument from the court was about whether or not vaccinations are good and how good are they. That really wasn't being disputed. All the lawyers would try to bring the court back to the issue that's really being disputed, the narrow procedural points. By the way, the government's lawyers did a very good job. I frankly expect they might win on the CMS mandate. I think it'll be narrow. They might win 5-4. I expect OSHA will lose, at least temporarily and at least in part. I suspect there'll be a 6-3 majority against allowing OSHA to force employers to send people home if they haven't been fully vaccinated or won't agree to weekly testing.
Send them home.
That's what has to happen starting February 9th. Starting today, employers must have all the reporting, record-keeping policy adoption in place and be tracking the vaccination status of employees. And you can be cited for that if you don't do it starting today.
Do they have to submit that information to OSHA?
On request, if OSHA requests it. So you've got to keep this tracking spreadsheet that OSHA can ask you for. They can ask you for all the backup records. So when you get your employee's little card, like all of us got when we got vaccinated, when they show you this and you take the photo of it and you put it in your records, they can ask for the employee's cards. As well, your tracking spreadsheet. They're trying to generate data on what percentage of the workforce is fully vaccinated.
So I assume, though, that the details of what the record keeping must look like, are those regulations or is that guidance standards included in the regulations, in the OSHA rules?
If you look at the Federal Register on November 5th, 2021, you will see a rule that's about 6 pages preceded by a preamble that's 150 pages. And you don't really know what the rule says unless you read the whole darn preamble.
Oh, gosh. So employers with more than 100 employees have got to go hire counsels, what they got to do.
100 or more, or you got to buy somebody's template set of policy, documents, tracking spreadsheet. I'm selling one, but all my competitors are too. And surprisingly, what we're all finding is everybody's waiting till today because everybody's hoping there'll be a Supreme Court order, administrative order, staying the OSHA mandate at least until they have time to write full opinions. And they're hoping, and I think it's pretty good hope that we might see that today. I've been refreshing my phone about every 5 minutes looking for it. I'll do it again right now. I haven't seen it yet.
Okay, so they could come out and stay that requirement of employers until final rulings are handed down. Is that what you're saying?
Yes.
Okay. And that's a long shot, maybe, but you think it's not.
I will be surprised if they don't. I don't know if they'll do it today, but I'll be surprised if they don't reimpose at least part of the original injunction until they can write full opinions.
Okay. So I know, obviously, you have many clients that would fit into this category of requiring to comply. Are they doing it?
Many of them are.
Okay.
The ones who are caught in the real bind are the employers who know that if they send the message to their employees that we're going to have to send you home unless you're fully vaccinated, those employees won't wait to be sent home. In this market, they will quit.
Already happening.
Yes, unfortunately, it's already happened. I might have told you this story when I was here last time, but a large employer in the southeast U.S. with about 28,000 employees ran a vaccination encouragement program spring and summer of this last year, offered $1,000 per employee to anybody who wasn't vaccinated who would get vaccinated. These are people who are making $15 to $25 an hour. They thereby upped their vaccination percentage from 37 to 41%.
4% by giving a grant.
By giving a grant. That tells you how strong is the feeling of people who don't want to be vaccinated.
Sure.
Those people will quit.
Yeah. And it's not really clear that it was because they gave them $1,000. Could have been other reasons that caused them to decide, okay, I'm going to get vaccinated.
Right.
Okay. So trying to buy them off doesn't seem to work.
For that employer and with that demographic and that classification of wages, it did not work like they hoped it would.
Wow. Well, all right. So you had shared with me you thought ultimately the final decision may be that employers will be, part of it is survives, it's sustained. Part of the I guess the requirement, the order is really what it is, order to OSHA to implement these policies. Is that kind of the legal aspect of that?
I suspect there's going to be a near-term outcome and a longer-term outcome.
Okay.
I think the near-term outcome is OSHA will be allowed to force everything except the mandate to send people home if they haven't been vaccinated or weekly tested.
Okay.
Before that final order comes down, I expect OSHA, however, to convert this emergency temporary standard to a regular old federal rule, and a regular old federal rule is judged under much more lenient standards than an emergency temporary standard. So most of the argument Friday in the Supreme Court in the OSHA case was about words that appear only in the emergency statute, the word emergency, the word reasonable, the word grave danger.
Okay.
Those words aren't relevant to regular old rules, which receive a great deal of deference. I think OSHA, if it sees the train coming down the track, they're going to jump off. They're going to jettison the emergency temporary standard. They'll convert it to a regular Administrative Procedure Act rule, and they will then ask for a much more lenient review.
Okay, well, that's interesting to know. So so does the Supreme Court, does it consider emergency versus standard differently, from a legal perspective?
Yes.
Okay.
They're actually different statutes. What OSHA is proceeding under right now is a statute that is in the Occupational Safety and Health Act of 1970.
Yeah.
Normally, when any administrative agency makes a rule, they proceed under the Administrative Procedure Act. What OSHA did in this case is to do both on November 5th at the same time.
Okay.
And they're enforcing right now the emergency temporary standard, but they've said the final rule is coming, and it can come as soon as January 19th. That's the end of the comment period. That's a week from Wednesday. A week from Wednesday, or the next day, OSHA could say emergency temporary standard is out. All the litigation about that is irrelevant. We're now enforcing the final rule, regular old rule under the Administrative Procedure Act, and the whole process might have to start again.
Man. All right, so I've talked to a number of members of the Mississippi legislature. I think every single one of them says this issue is number one in terms of what they get called about. It's the top issue, is opposition to the mandates, concern about that. Many of them calling for the state to act and to enact some sort of law that essentially does not require or nullifies the federal requirement. How does that work?
Well, if you come down on the side of OSHA has power to do this, then you have to conclude that its power to do that displaces contrary state regulation.
So then, in effect, the law really would have no power, would have no effect?
It's something that courts reviewing the regulation will look at to determine the consequences but it doesn't receive a lot of weight.
Oh, my gosh.
If OSHA can regulate commerce in this way, then states have to give way.
You want to hang around? We got a break here. I got a couple more questions about from an employer perspective and how they manage through this, and get your comments on what at least one of the justices had to say that turned to be just blatantly false during the hearings.
Just one?
Just one, yeah. We'll be back. We've got Pepper Crutcher, attorney with Balch Bingham, in the studio. We're talking about the vaccine mandates. Middays will return. We've got attorney Pepper Crutcher in the SuperTalk Studios. We're talking about the Supreme Court hearings on the vaccine mandate. So, Justice Sotomayor, she is under fire, I think is a polite way to put it. First, for overstating the number of children that are currently hospitalized with COVID. She said 100,000 and said many, quote, many are on ventilators. And that's been proven totally false. It's more like 3,500, of which only a handful are on ventilators.
According to the CDC yesterday.
According to CDC. Correct. Although CDC Director Rochelle Walensky, when questioned about it by Brett Baer, she didn't really seem to want to go down that path. She kind of, well, I mean, she kind of stuttered and stammered. Well, yeah, but, and then she went on to her case for, what they're trying to get done on the vaccination front. She also said that Omicron is as powerful and produces
deadly.
As deadly. That's right. That's what the word she used, as Delta, and that's pretty much been established and I think agreed to in the scientific community not to be the case. And based on outcomes, that appears. I mean, the data supports that it's not. So, why do you think she would how, first of all, could a sitting Supreme Court justice, an intelligent person, with all of this information widely available to any of us, honestly, why would she make such a mistake?
My first just gut level reaction was, how did she get on the Supreme Court? How can somebody that ill-informed? And then I thought, no, she's a Yale law graduate. There was a reason behind what she was doing. Was she just trolling us? Maybe she was having fun with us. I don't know. Was she saying things she thought would improve the debate from her side politically that she thought would be covered uncritically, and therefore was she making basically campaign statements for these regulations? I don't know, but I do know this from a lawyer standpoint. The government's lawyers were doing a good job. And time and time again, because of things she said from the bench, and to a less extent, Justice Breyer, they had to get off message and go try to dig out of a hole because of things she said. Justice Kagan helped out some. Justice Kagan performed very well, too. Justice Kagan directly addressed the strongest points of the other side. You could tell she made up her mind, but she was genuinely trying to make sure she understood what the other side was arguing. Mm-hmm. You didn't get that from Justice Sotomayor or Justice Kagan, and I don't know why, because I think they would have helped their side better if they had taken the Justice Kagan approach.
Well, it almost seems that you even made a comment off the air that I don't mind sharing. Was it intentional? I mean, to try to get us all riled up, say, see, but this, as you said earlier in the last segment, that's not what's at issue here.
Right.
That's not what's being challenged from a legal perspective. Is it? I mean, is the government's case strengthened by the fact that this is a serious health problem? Does that enter into the equation?
Well, that was Justice Breyer's entire subject for the whole day of argument. The Chief Justice, Justice Roberts, normally is very reserved in his comments and questions, especially in cases where he's going to be a deciding vote.
Okay.
But after a couple of things that Justice Sotomayor said, he jumped in on the OSHA mandate case with both feet and started making some pretty strong statements and asking some very pointed questions, one of which was, are we supposed to ignore that every federal agency that's got any sort of regulatory power is issuing a vaccine mandate? Isn't this an example of the federal government trying to do what it doesn't do, which is to exercise a general police power, because it doesn't have authority to do it. Are they just calling these agencies regulations when they're really trying to act like a state government ordering the population to be vaccinated?
Yeah.
If the CMS mandate goes down, I think it'll go down on those grounds, because on its own, just looking at it in isolation, the CMS mandate had a pretty strong argument made by the Solicitor General.
So is this a situation, you think, Pepper, that if the Supreme Court were to rule in favor of the government, is this some sort of so-called slippery slope that would just kind of set the precedent for government, certainly at the executive order level, to impose anything that's sort of out there
I
like
think
this?
that's the way Justice Roberts understood the OSHA argument, and I think I remember correctly, he jumped in with both feet after Justice Sotomayor agreed with the petitioner's counsel that, of course, OSHA could regulate employers to address a general societal risk of terrorism. There's literally no limit of what OSHA can regulate society about, as long as they can find the regulation to doing it through employment.
Yeah.
That, I think, greatly disturbed Justice Roberts and others on the court, which confirmed their worst fears about the slippery slope.
Yeah. All right. So what about the federal contractor mandate? That was the third of the three.
It was not argued.
Not argued. What's the status of that?
There are injunctions in place. It's working its way up, but it's behind the proceedings for the CMS mandate and the OSHA mandate. And frankly, I'm not paying attention to it right now for that reason.
Yeah. Okay. Well, one of the concerns, of course, is that in Mississippi, the Board of Institutes of Higher Learning acted, requiring the institutions to instate the mandate in accordance with the rule that was issued by the White House. But now that that's been enjoined, there are many citizens that are calling for them to take a change of stance on that.
Right. And I think the universities have, haven't they?
I don't know.
I think the universities have.
Okay.
I think they've stayed that requirement of university employees.
Okay. Well, appreciate that. I wasn't aware.
Yeah.
All right. So, but what about an organization that is a federal contractor, but also an employer that meets the 100-employee standard?
Yeah. So the rules need to talk to each other, and that will have to be worked out administratively. So OSHA, before they rescinded their health care vaccination mandate, they said that your general mandate won't apply if you're covered by the health care vaccination mandate. They've now rescinded that. They've left the record keeping in place,
okay,
the one they established last June. But they're now saying all of you will now be covered by the general OSHA emergency temporary standard.
Gosh, what a mess.
It is.
It's a total mess. All right, so this is something else that occurred to me. There are a lot of those in the medical and scientific community that are predicting that perhaps as early as 2 weeks we may be sort of past this surge and on the downside of the spread and the cases and so forth, and entering kind of the endemic phase. It seems to make this even less necessary. Is that something that enters into the argument?
Yes, it did, especially under the OSHA statute, where the words reasonable, necessary, grave danger, emergency. But the counter-argument to that is, look, we can't be basing what the law is on transient facts that may or may not apply 2 weeks from now. If the government has power to do this, then they have power to do this. If they don't have power to do this, they don't have power to do it regarding how pressing the circumstances are.
Yeah, I hear you, but, I think you put me down in the camp that says, you guys hadn't understood this from the beginning. Why don't you just come out and say, we just don't know. There's just a lot of stuff we don't know. We learn more, and we adjust. But every time they adjust, they never go back and say, sorry, we called that wrong, and this is our kind of updated guidance and standards. That seems to be embedded in this entire deal. Honestly. I mean, do you not see that? Sure you do.
When I was a brand new lawyer, I had a meeting with the regional director of the National Labor Relations Board in New Orleans, who is an old curmudgeon, but he liked to talk to young lawyers. And so he said, here's what you'll find true about our agency. We may often be wrong, but we will always be consistent. If we're wrong to start with, we're going to be wrong all the way to the Supreme Court.
That, I think, pretty much characterizes what has been the case here.
They're never going to admit they were wrong.
I know. But I think people are just tired of that. And I think people are generally, they'll give you a break. They're receptive and I think respectful of those who come out and are just honest about it. We just don't seem to be getting anything that is consistently honest. It's just, okay, here's the updated deal, take it, or we're going to fine you.
That's one of the things I've liked about how Thomas Dobbs has handled things in Mississippi. I've gotten the impression that he's doing his best to level with the public.
Okay. We got the music playing, which means we're about out of time. Quick question. Are there fines imposed or still in place for employers? Let's say that the end result is you got to do all this record keeping, and that's pretty much it. Do you get fined for something there?
Yes. The good news is OSHA doesn't have enough inspectors to be able to catch everybody or even most of everybody, thank goodness. But, yes, starting today, you can be fined for not having the record keeping in place.
Okay. But that's not the same as the $13,600 per
serious violation, yes.
Oh, okay. It is. Oh, my gosh. More government. Pepper, appreciate you coming on and unraveling all that stuff for you, and I'm sure we'll be talking to you more. We'll take a break here on Midday's final segment, first hour.